the prayer for reinstatement. I wish, again, my Lord, your leadership, to reiterate that position on record. My Lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August, 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law. Finally, for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic. Okay. It is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the submission. My Lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2024. Number two, his bundle of authorities and case digest, dated 7th of October 2025. And number three, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this noble court. My Lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My Lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize to emphasize the total and absolute lack of meaningful public participation. And I would draw this Honorable Court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this Honorable Court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10, and 11, and they appear from page 8 of our written submission. Paragraph 8, the Lord, you see, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution and the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination. In this Honorable Court, you'll be taken through all that. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Brigadier Gachagua. And also RG 12, volume 9, pages 1752 to 1758, communication from Nigeria. My Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by vote, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that there are breaches of the Constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Record, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kyoko, and another was Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. But Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different councils. Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations. Whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wabora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other reasons. No, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case, deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's a very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country, and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office. By impeaching the Deputy President on the basis of a section that had been nullified by this court, what he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, alike case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. You find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the alike case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly, stating had been violated by the first petitioner, criticizing the NIS director. My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Civilian Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply